What is going on, guys? Welcome back to another podcast. Today we're going to be playing some Team Fortress 2 and talking about some Supreme Court cases. So our first topic is going to be over the First Amendment, more specifically, freedom of speech. Take it away, Joseph.
Alrighty, so the first case we've got, it's from 1964, and this is the New York Times Company versus Sullivan. So this concerns the First Amendment, as we said. And it concerns libel law in Alabama, and if it unconstitutionally infringes on the First Amendment's freedom of speech. So it basically concerns where the line is drawn between the press unknowingly presenting false information versus presenting false information with a malicious intent, or with the intent to slander, basically. So there was an ad run in an Alabama newspaper through the New York Times with false information. And a city public safety commissioner, L.B. Sullivan, although he wasn't actually mentioned in the ad, some of his subordinates were, and he was worried that his image would be affected by the false information in the ad. So he sued the Times, and in court won. He was granted $500,000 in damages. The court found that it was a libel action lawsuit, and so he was awarded. Basically, the court was like, yeah, that was bad. They shouldn't have done that, and for the reputation damages. And then it was brought to the Supreme Court. The Supreme Court unanimously ruled in the Times' favor, stating that for the issue to technically be libel, like slander, like that, the Times has to be it can't just be that the information was false. It has to be proven that the Times knew it was false and was presenting it to the public explicitly, knowingly, that it was reckless, or that they're posting false information with malicious intent. And because that couldn't be proved necessarily, the court ruled that Mr. Sullivan should get nothing in damages, that there aren't actually any damages. It sort of presents the question of where the line is, and especially now with fake news, air quotes, but where the line is between how you can prove that someone's doing something with malicious intent, false information with malicious intent, versus just unknowingly presenting false information. And I wonder why it's not brought up more or fought more.
Yeah, this is kind of interesting. I feel like companies could definitely get away with slander just if they could prove, or if they could at least get people to believe that they didn't do it intentionally.
Yeah, it's proof of intent is just kind of lost there. I feel like it's kind of a useless. How do you even prove a libel action lawsuit in general?
So we've got another case here that I think relates to that one pretty well. This case is all the way back from 1919, over 100 years ago, called Schenck v. United States. So, how this case went down was, this guy Schenck, this outspoken socialist, during World War I, he publicly advocated that the draft violated the 13th Amendment, which is already an interesting enough idea on its own, but he urged the public to disobey it, explicitly stating to disobey it peacefully, however. He was charged with conspiracy to violate the Espionage Act, saying he intended to cause insubordination in the military. So the court ruled unanimously in favor of the U.S., saying that the government should be owed much more deference during wartime, even when constitutional rights could be at stake, and that resisting the draft is unlawful, and he was advocating for a crime. They kind of compared it to shouting fire in a theater, which, mind you, isn't supported by the First Amendment. And so basically, this kind of relates to the Constitution, in that it stated that the Constitution can't protect speech that is creating a clear and present danger of a significant evil that Congress has the power to prevent. And I find that pretty interesting, because, what does that mean? What does clear and present danger mean? At what point is an evil significant enough? It's very vague speech.
And I just think it's a horrendous take. I think you should peacefully. Aren't we constitutionally within the right to overthrow the government if it becomes tyrannical? I mean, how do you even define that? There's lack of lines. Everything's opinionated.
And I think even the take that Schenck had about the draft violating the 13th Amendment is pretty interesting, and wasn't really investigated much at all. Yeah, I mean, does the draft violate the 13th Amendment? Right? Servitude, basically forced against one's own will. I mean, I guess in return for protection and citizenship under the U.S. government. But, still, it's hard to draw the line there.
Hot debate,
But on to overthrowing the government, we actually have a case just about that. This one is Gitlow v. New York. This is from 1925. A pretty similar case to Schenck v. U.S., in that Gitlow was an outspoken socialist who distributed a socialist manifesto, basically kind of saying that there needed to be a violent overthrow of the government. And he was arrested under New York's criminal anarchy law. Gitlow argued that since no actual action came from his pamphlets, no one actually tried to overthrow any government, that the state can't claim that he sought to incite violence. So the court ruled 7-2 in favor of New York. They believe that the government can and should punish speech that threatens its existence. They also rule that freedoms of speech and press don't apply specifically to the states. The states can't enforce them. That's just a federally enforced law, or I guess, amendment. And so, I think this one's pretty interesting.
Well, I mean, once again, you have like where the lines are drawn, and it's like, what if and how do you know the intent as a governmental body judging whether someone has the intent to overthrow or not? How do you judge someone's intent? How do you judge if someone? I mean, I could right now be like, yeah, I want to overthrow the government. Like, should I be arrested? I don't know.
Mm-hmm. And it scares people away from just criticizing the current government, because obviously no government's perfect. And when you talk about even if there's no actual intent, if there's no actual actions taken towards the government, just saying that the government should be overthrown can be viewed as illegal. At what point does criticizing the government count as saying it should be overthrown?
Where does criticism become revolution, basically?
Absolutely. Interesting takes, hot takes.
Things to think
interesting.
About, make you mad at the government a little bit, maybe?
Yeah, absolutely. So let's head over to our next interesting idea here.
All right, so next we've got Greg versus Georgia, shifting gears a little bit about the death penalty. 14th Amendment, cruel and unusual punishment, right? So Greg was found guilty of armed robbery and murder, sentenced to death. He challenges his death sentence, yet as a cruel and unusual punishment. Court decided, 7-2 decision, decided that the death penalty doesn't violate the 8th and 14th Amendments, and that in extreme circumstances such as his, the death penalty is appropriate if carefully employed. So this shows that the government can use capital punishment, use it as a deterrent against capital crimes, and is a perfectly appropriate means of social retribution against serious offenders.
I really like how they say it's appropriate if carefully employed. Mm-hmm. Like they're aware of the fact that it can be inappropriate and that it can cause a lot of problems. But just if they're careful about it, it'll be fine.
They get to choose. When they
right, absolutely. And the whole thing about it being carefully employed, this is a big problem with capital punishment all around the world, is that inevitably, if a country allows capital punishment, innocent people will be killed. The only way to prevent that is to just spend more money on it, take more time on it. And right now in the U.S., it costs, something upwards of $1 million to put someone to death. Yep. And, a lot of time, a lot of energy for a lot of people. And still, even with the system they have now, there are still cases of, innocent people being put to death.
It's not even worth the risk.
Mm-hmm. I think, especially for the idea of social retribution, which I think the government is not in the place at all to act out. If you're going to try to act out social retribution and then end up enacting that on innocent civilians, I think it's a practice that should be abolished, frankly.
Completely agree.
I think we've got another case here, on the topic of life and death, as someone put it. Yeah. We've got Roe v. Wade. This is a very, very controversial, very popular case. One you hear a lot today.
Current events.
So took place back in 1971, and it's it's pretty well known. Basically asking, does the Constitution recognize a woman's right to terminate a pregnancy by abortion? It argued against a Texas law that abortion was only allowed by doctor's orders to save a woman's life. Argued that it was vague and violated the First, Fourth, Fifth, Ninth, and 14th Amendments. So the court ruled in Jane Roe's favor, basically saying that, right, it was, a very poor and a very vague law, and said that under the 14th Amendment, there is a fundamental right to privacy that protects a pregnant woman's choice to have an abortion. Very popular case today with the government, tapping in and, I guess, getting to decide what some could consider life. Especially after hearing, time and time again that quote, Roe v. Wade will never be reversed. Here we are reversing Roe v. Wade.
Literally.
In the same state that caused it to exist in the first place. I think that's all we have time for today.
It's unfortunately.
Yeah. Thank you guys for listening in.
Yeah.
See you next week.